Welcome to InstaLegal. The question that we have for discussion today is who gets the custody of child in India? Now, this kind of an issue where who gets the custody of the child comes up only when the parents are having internal disputes. For example, the mother takes the child with her, being annoyed with the father of the child and decides not to return. In such situation, either she allows the father to meet or speak with the child, or she tutors the child against the father. In many situations, the child, if of a very tender age, is not made aware about the father himself, and the father is not even allowed by the mother to meet the child as well. So, what can a father do in such circumstances? And if it is vice versa, then what could a mother do in such circumstances? Let us understand the child custody law in India. The term custody is not defined in any law specifically. However, from various decisions and other provisions of law relating to custody, it indicates that the custody could be either physical custody, joint custody, or legal custody. It is to be differentiated from the word guardianship. It is not that custody of a parent would be with a guardian always. So the provisions which are dealing with the custody law in India, specifically with regard to the Hindus and the others who are married under the Special Marriage Act, they basically are under provided Section 26 of Hindu Marriage Act, Section 28 of Special Marriage Act, Hindu Minority and Guardianship Act 1956. It specifically deals with the custody issues, the welfare of the minor and the guardianship issues of a child, and the Guardians and Wards Act of 1890. Now, Section 6 of the Hindu Minority and Guardianship Act, it constitutes the father as the natural guardian of a minor, but as per the view of the Supreme Court in various decisions, such a provision cannot supersede the paramount consideration. Now, what basically is the paramount consideration is what we have to understand to know basically who will get the custody of the child. Let us understand the kind of custodies which are recognized. It is a physical custody, wherein a child is under the care of one parent who has been awarded the custody by the court or by mutual agreement between the parties, and while the other parent may get the right to visit the child and interact as agreed on mutual basis. Then it could be a joint custody where the child is rotated between the parents one after the another, allowing both the parents to spend quality time with the child. Both these kind of custodies help the child to grow in a very balanced manner. Another kind of a custody is a legal custody, which is usually granted to both the parents and doesn't involve presence of child with one parent, but the legal custody gives right to both the parents as to decide about the maintenance issues, the educational expenses, etc. for the child. Before we discuss how the Supreme Court has dealt with the issues of child custody, it is important to remember one thing, that each case is to be dealt with on the basis of its peculiar facts. There is no hard and fast rule as to who will get the custody of the child, whether it would be a mother or the father, but the trend as we see is that the mother usually, if it is a minor, will get the custody of the child. So let us see some cases. Supreme Court has held in one of the cases that the expression best interest of child, which is always kept to be of paramount consideration, is indeed wide in its connotation, and it cannot remain the love and care of the primary caregiver, that is the mother, in case of the infant or the child who is only a few years old. The definition of best interest of the child, which is envisaged under Section 2(9) of the Juvenile Justice Care and Protection Act, is meant that the basis for any decision taken regarding the child is to ensure fulfillment of his basic rights and needs, identify social well-being and physical, emotional and intellectual development. If the best interest of the child is seen, then whichever parent is able to give the best interest of the child or the best welfare of the child would be able to get the custody of the child. In another case, the Supreme Court has said, though Section 6 of the Guardianship and Minority Act says that the father is the natural guardian of a minor child and therefore has a preferential right to claim the custody of his son, but in matters concerning the custody of a minor child, the paramount consideration is the welfare of the minor and not the legal right of a particular party. Section 6 cannot supersede the dominant consideration as to what is conducive to the welfare of the minor child. Thus, it was observed by the Supreme Court that keeping in mind the welfare of the child as the sole consideration, it would be proper to find out the wishes of the child as to with whom he or she wants to live. So this is one of the main conditions. If the child is intelligent enough to make an informed decision, after the court interacts with the child and finds out that there is some kind of intellectual in the child and the child is capable to decide as to where he can be more comfortable with, then if the child says that I want to be with the father, the custody would go to the father. The issue is that the welfare of the child shall include factors like ethical upbringing, economic and financial stability, health, education, etc. It is also said that while the court exercises the power of parents patria jurisdiction, the court is required to give due weight to the ordinary comfort of the child, contentment, intellectual, moral and physical development, health, education and general maintenance, and the favorable surrounding. The court is not bound either by the statutes, nor by strict rule of evidence, nor procedure or precedent. In deciding the issue of custody, the paramount consideration should always be the welfare and well-being of the child. So the only thing, as I said in the beginning, that each case is to be dealt with on the basis of its peculiar facts. So if the facts suggest the welfare and the well-being of the child with the mother, then the court will grant the custody to the mother, and the other parent, that is the father, can get visitation rights, can get visitation rights or the meeting rights. And recently the Supreme Court has also said that if custody is being granted to one parent, the other parent needs to make sure that the child speaks to the parent who does not get this custody every day. So it is not that the court wants to deprive the child of its fundamental right to have the love of the parents, but it has to balance the love of the child for its parents with the welfare and the well-being of the child, depending upon each case circumstances. Thank you very much.